In any case, second half of the book. First chapter of the second half of the book is very different from the rest of the second half of the book. It's a history, and it is very well done, very well documented, heavily footnoted. He presents some really important principles of justice that fit with biblical principles of justice that the United States government put in place from the very beginning. And then he presents some ways that they didn't actually do that well, or completely, or over time it got even worse in some ways. One of the problems at the outset is that these principles were put in place in the United States Constitution at the federal level. They were not applied at the state level. So some really important biblical principles, like the right to a jury trial, the right to um, uh, some of them were very particular things. I'm trying to remember what they were in detail. Um, the right to everyone being treated the same really is one of the things are not applied at the state level, and particularly once you get things going for a while, new things are put in place that have really two different justice systems for white Americans and black Americans, many of whom were enslaved, especially in the South. And during the time of slavery, then, you would have a different justice system. You wouldn't have trials for slaves who were accused of crimes. You wouldn't have due process then. You wouldn't have anyone examining whether the person giving this evidence against this slave was actually telling the truth. Uh, you didn't have rights that were observed across different group lines, right? And that's partiality. That's a violation of the principles that we were just talking about. So, and there's lots and lots and lots of cases of these, and it got worse and worse over time. And particularly, even after the Civil War was over and slaves were freed, you started to get justice codes put in place. And even before Reconstruction was over, some of these states were putting things in place that were two different justice systems. Although some of them got removed with the amendments that went in after the end of the Civil War. But a lot of that stuff was just not enforced. And the Supreme Court eventually heard some cases and said, yeah, they don't have to be enforced because it's separate but equal, is what they said. But it wasn't equal. And there are many, many ways that it wasn't equal. One of the ways that it wasn't equal was particularly egregious. The black codes, as they were sometimes, as they came to be called, were ways of providing uh, ambiguous laws that could be enforced as prosecutors and as cops decided to enforce them. Laws like vagrancy laws and things like that, that would make it a crime. And one of the things, one of the biblical principles in the first half of the book that I didn't mention was uh, uh, when you choose to call something a crime versus a violation, right? Speeding is a violation most of the time, right? In a couple states like Virginia, if you go over a certain amount over the speed limit, it becomes an actual crime, and it goes on your criminal record. Um, we need to be careful about what we call crimes, right? And even within crimes, felonies versus misdemeanors, that label makes a huge difference, especially because in many states, felons are not allowed to vote, right? So here's what they were doing though, and they were saying they were doing this. They were out loud saying they were doing this. You have records of their discussion in the legislatures saying we're doing this in order to make sure that slaves can't, or free black Americans, Negroes they would have said then, can't vote. And how do we do that? Because the Voting Rights Amendment is there. How do we do that then? Well, we'll have these crimes that are vague enough that it's easy to arrest people for them when they're not really doing anything terribly wrong. And we'll call it a crime and we'll call it a felony. And once we put that in there, they can't vote anymore. Uh, Similarly, slavery is banned by the Constitution. Except there's a little exception written into there that says, except as punishment for a crime. Well, how was that taken advantage of? The crime would be administered for whatever vague thing they were doing that the black codes called a crime, right? And then they would get their sentence, and their sentence would be they would be sent to go work on a plantation as a punishment for their crime. And I mean, this was basically called uh, leasing of a person. They couldn't sell them; that's illegal. But they could lease them to work. But because they weren't permanently property like slavery had it, there was no sense of investment in the person. That I don't want to make sure this person doesn't get injured because I want to keep them working for me for perpetuity, right? You don't have that incentive anymore, and so they were even harsher in this environment than they had been when slavery was in effect. There was one particularly egregious case of a guy that was basically killing all of these people and dumping their bodies in the woods behind his plantation and stuff like that. It was just absolutely awful stuff. And the black codes were a way of coming up with a separate criminal justice system for black Americans that really constitutional rights should have prevented them from doing, except they weren't heeding that. And it was only gradual after the 14th Amendment came into place, the Supreme Court started to recognize over time that some of the amendments of the Bill of Rights, because of what the wording of the 14th Amendment, actually apply to state law as well, not just at the federal level. Most criminal trials are in the state system, not in the federal system. So most criminal rights were not having the Bill of Rights being applied. And it was only very gradual after the 14th Amendment existed that the Supreme Court started to say, hey, that right, 14th Amendment, states have to observe it too. And so you're still getting decisions saying things like that 100 years later in the 1960s saying, hey, that right, it's incorporated into the Bill of Rights. Bill of Rights is, 14th Amendment incorporates the Bill of Rights into states, right? So a state has to observe that right. And it's 100 years later, you're still seeing the Supreme Court coming to a recognition of that right or that right or that right having to apply at the state because of what the 14th Amendment says. So the entire time of Jim Crow, um, you're not having that happen. And so these rights are not being observed. Um, and of course, the worst case is lynching. And I didn't even know this. I'm a race scholar, and I didn't know this sort of thing was going on. You would have newspapers post something about an upcoming lynching. They would post an announcement about it a week ahead of time, and people would come from all over and come to the thing and take photographs and have a blast. There would be food vendors and all that. They knew this was happening a week in advance, right? Obviously, someone had to inform the newspaper that it was happening, right? And then they would kill the person. They gruesome, awful stuff. They'd like force uh, uh, parents to watch their children's fingers be cut off and burned to death before they finally did the same thing to the parents and then burned them or whatever, and just awful stuff. And then the newspaper would post an announcement saying, "So and so was killed by persons unknown." They knew full well who organized the thing, right? They would have known ahead of time to put that advertisement in there if they didn't know who was doing it. And by and large, it was the leaders of the community. And there were even times when a case did go to court. They didn't get lynched. They actually made it into the court system, and then they would get acquitted of the crime. And as soon as they leave the courtroom, the lynching would happen, and they'd be killed anyway, and stuff like that. I mean, absolutely worst stuff in the history of this country in terms of the justice system. So that's the history, and I think a lot of Americans don't know quite how bad it really was, and it's just there's a lot of ignorance about this kind of thing. So I'm an actual race scholar, and I probably don't know how bad it really was, right? I can imagine most Americans know a lot less than I do about it. So in any case, we get to the second half of the book. The second half of the book, after that one chapter, is about very particular areas of uh, things that we should be paying attention to. Oh, actually, I was wrong a few minutes ago. The crime thing is the next thing. How did I miss that? The crime, determining what is a crime and what is not a crime. So I just said something about that already. There's a chapter on that. There's a chapter on we should, plea bargaining. Now, this was I knew there were issues with plea bargaining, and I could see even watching Law and Order episodes and things like that. Something doesn't seem right about how this is going on here, right? But I didn't quite see the argument for why our plea bargaining system is thoroughly unjust until reading this book. I think he does a really good job of explaining why. There's a coercive element to the plea bargaining system. The way it typically works is you set up a coercive set of circumstances where um, part of it is affected by bail. Some people can't afford bail. Some people can. Those who can afford bail can go hang out and live their life at their home and live their life as normal until they have a trial. But those who can't afford bail, and then we actually need to think about the part of the argument for bail reform is because of cases like this. Um, because they can't afford bail, they have to be in jail while they're awaiting their trial when they haven't been convicted of a single thing. So we're punishing them for something that they haven't been convicted of, right? Is that okay? I don't think it is actually. I don't think it's morally okay to lock someone up when waiting for their trial, unless we have a really strong moral reason to do so. For example, if the evidence is so strong that they did it, that we think it's almost certain they're going to be convicted, and they're probably going to endanger people's lives in the meantime if we don't have them held in lockup. That I understand. But if they shoplift at a candy bar and we're holding them because they can't afford their bail, that seems thoroughly immoral to me. So anyway, this is held over their head. You're going to have to sit in prison until you wait for your trial, which could be 2 years down the line or whatever, right? Who knows how soon it's going to be. Your life will be disrupted. You can't go to work and earn money. Your relationships might fall apart. You might be left by your girlfriend or wife or whoever it might be, right? And you might lose your children in a custody battle. These things all happen to people in those circumstances, and they may have not committed the crime, in which case they want their trial, because if they plead guilty when they didn't do it, they're not only are they doing something wrong, they're lying, but it's unjust and they don't deserve that, right? And yet there's this coercive situation. You get to go free if you say that you committed this crime, but otherwise you're going to have to wait in jail and have your whole life be disrupted because someone accused you of a crime you didn't commit. Is that just? Right? It's not. That's coercive. And often it's even made worse because they'll put some ridiculously high sentence that's totally disproportionate to the crime, and say, if you go to trial, we're going to throw the book at you and we're going to do this ridiculously high sentence. But if you plead guilty, we're going to give you a much lower sentence than what the crime deserves. And if they actually did commit the crime, that's also unjust, right? So it's the whole plea bargaining system that we have in the United States is, and the vast majority of crimes that people get arrested for get plea bargains. The vast majority of them. Very few cases go to trial. Um, so that's a clear violation of principles of justice. I don't know what to do about that. I don't know what way to move forward from that. But the situation as it stands, the practices that we currently engage in, the structures in place in society are completely unjust. And his chapter really demonstrates that very, very clearly. I saw cases in Law and Order episodes that seemed really unjust to me, but I didn't realize how unjust the entire system of it is until now. I think it's pretty bad. Um, a few more chapters on issues, and then I do need to get to my son and figure out what he was trying to get my attention about. Jury selection. Biggest problem in jury selection that Matt points to in this book, really, really, really big deal, is there's a long history of racial bias in selection of jurors. And the way it went for a while, and it was allowed to go a while because people didn't do anything about it, was they could simply give race as a reason for excluding someone from the jury. And so you could have only white jurors for a black defendant, say, right? Eventually, the Supreme Court said you can't do that. You have to give a race neutral reason for excluding someone. And they started to do so. But you would even still, after that, have cases where you would see a single prosecutor, 10 years of cases where they had not a single black juror for that entire 10-year period. And I'm not talking about 1960 here. I'm talking about 2000, 2010, that kind of thing. You still see this kind of thing going on. And there are cases that have gotten overturned because they had an all-white jury. And then they would have to have a retrial. And sometimes when you get the black jurors on there, they still get convicted, and sometimes they don't. But they get a retrial in those cases. But the prosecutors who do that kind of behavior have immunity. You can't hold them accountable for it. That goes against the biblical principle of accountability. What they're doing is illegal, but there's no way to hold them accountable. You can have the trial be redone, but you can't have them removed from their position because of it. There's no provision for that. It's thoroughly unjust to have no mechanism for removing a bad actor, right, in the judicial system who's consistently doing something absolutely terrible. Chapter on judges. I think the main argument there of something that Matt has identified that's problematic is, and there's this long-standing debate, should you have elections for judges or should you have them be appointed? The argument for elections is you're holding them accountable to the people. I understand that argument. I don't think it's a terrible argument, but the argument for appointments is stronger, I think, and I think Matt gives some really good arguments for this. That's because when you have elected judges and you hold them accountable to the people, all of the biases of the people electing them get in place. Well, what biases? Well, I already mentioned this. There's a much greater likelihood for voters to want judges that are tough on crime. And that means that they're going to be biased toward prosecutors and against defense. Because they want their voters to keep voting for them. And the reason they got in there in the first place is they said they would be tough on crime. And it gives them a much greater likelihood of being biased in the direction of harsher penalties than is deserved, much greater likelihood of wanting to demonstrate that they are tough on crime rather than soft on crime. And if you just look at this, someone posted something to social media last week of a too light sentence on crime, and people jumped all over it. Does that happen when someone has a sentence that's too harsh? Not to anywhere near the same degree. It's I think his arguments are pretty good here, that when we have judicial elections, it makes it much more subject to a bias in who will be favored in court, because the judges that have that emphasis have a bias. They simply do. And if that's more likely to happen with elected judges, then maybe we don't want to elect our judges. I think that's a pretty good argument. So there's a few other things in here, but judges being impartial is the main thing in that chapter. Assistance of counsel, there's a history of not providing attorneys, particularly for black defendants. Eventually we got to a point where that right was put into place, even at the state level. But there is a pretty poor discrepancy between the pay of prosecutors and the pay of public defenders. And you can't recruit the best defense attorneys to provide counsel, which is a constitutional right, to defendants who can't afford an attorney. There are, in some states, provisions for just appointing an attorney, and then they have to do it. But that's kind of random, and it's really hard to find the best people do it. And often you get the freshest people who don't have a track record or not really, and then they go on to better things, right? Once they get more experience. Um, and the biggest problem is not so much whether they're good or bad attorneys, but whether they have the time to do it. They're given so many cases, there's so few that are able to do that kind of work in a lot of these states, depending on the laws of the states, that it's not an equal system. The prosecutors are the ones who have all the resources, and prosecutors have advantages as well. They have the force of the law behind them. They can force people to testify with a subpoena. Defense attorneys can't do that. They don't have that power. So there really are advantages to one side rather than the other that allow for injustices to be more likely to occur. For example, the ability to hide evidence and not turn it over, which they're legally required to do. That's also an accountability issue, uh, because again, there's some level of immunity going on here, where I mean, if they hide, I mean, if they hide direct evidence, they they um, they can actually lose their law license. If they have evidence that demonstrates that the defendant didn't commit the crime, and they don't turn it over to the defense, and that gets found out, then they can actually lose their law license, then never practice law again. That is an accountability thing that's there. But there are other kinds of evidence that they don't get punished for not turning over. For example, if they have evidence that shows that the key witness in the prosecution is biased and maybe telling a fictional story or something like that, and evidence against their character, and the defense attorney never receives that evidence, there's no penalty whatsoever for the prosecutor. And the Supreme Court has actually affirmed that there shouldn't be. They have immunity on that kind of an issue. What does that mean? That means that there's no enforcement. There's no accountability, right? In those cases, at least. I mean, you could get a retrial, but you couldn't get that person ever facing any personal penalty for it. So that's exculpatory evidence. That's and then we have a chapter on witnesses. Um, I already mentioned one of the things there. It's very difficult to get a person um, to um, witness if you're a defense attorney sometimes, whereas the prosecution has the power of a subpoena, right? But one other issue with witnesses is testimony from confessions. There's a very poor track record of confessions uh, by people who are not guilty. Why? Well, sometimes it's at the end of a very long interrogation session, done in thoroughly immoral ways, really, honestly. Some of the things they do to people when they're having them testify is just, I think, should be criminal itself. And some of the things they can do, the lying to them and things like that. When you're on board with trying to get a really bad person uh, to admit to doing the thing that they did, it sounds not so bad. You see people do it on TV shows, cops saying, "Oh, your buddy over there already turned you in. Now you better turn him in too, right?" Um, but honestly, you're not treating them as you're not loving them if you're lying to them. You're not treating them as a person made in the image of God if you're deceiving them into testifying, right? And out of self-protection or whatever, right? It's not that kind of dishonesty, I think, is not okay. And the bullying that can take place over a very long interrogation period, the person on the other end they can swap out the cop, but they can't swap out the defendant, right? Or the accused. And they may be so tired they just want the interrogation to end, and so they might admit it even though they didn't do it. And the reality is the majority, I think this is the statistic. I don't have it right in front of me, but the majority of people who are in prison have some kind of either cognitive disability or mental illness. The majority of them. And so when you have that disproportion going on, what is it that's happening in that interrogation that's it's very easy to see how someone who isn't as capable of clear thought could be manipulated into testifying that they did something that they didn't do, just so that they can have the pressure off, so they can end it. And they're not thinking long term. They're not thinking rationally. They're not thinking what's going to happen to me if I say I did it. They just want the thing to end, right? So there's all sorts of ways we can think about how that could happen, that people could confess to something that they didn't actually do. And there's so many cases now. What the Innocent Project has discovered with DNA evidence and things, really establishing that someone didn't commit the crime, even though they testified that they did. They confessed to it, right? That there's so many cases of that now. That we need to be much more careful in how we think about confessions. So, there's some interesting stuff about forensic evidence as well. I'm going to leave that aside. Um, a couple more things. Sentencing and the death penalty are really the last 2 points. So, sentencing, the main point of that chapter is to think about sentencing guidelines. Sentencing guidelines have an advantage over not having any. How so? Well, let me give you the case of Socrates. Socrates, in his system, he's convicted of a crime. He gets to suggest a penalty. The opponent suggests the penalty that they want. They want death. What is he left doing? He has to try to figure out a penalty that's he's comfortable with, something he'll accept, that's better than dying, but that also is something the jury would actually be willing to give to him. And he doesn't actually manage to come up with one. There's some things that they could have done that he's unwilling to accept. And so he doesn't suggest those. And he ends up suggesting a fine. And then his friends say, well, we can increase that. He's willing to pay all he's got, but it's not all that much. And they throw in their amount. And the jury says, well, that's his friends buying him out. They're going to have to go with the other one. If we just convicted him of a crime, the only option is to sentence him to death. Otherwise, he goes free. And his friends pay for his way out. And so, of those who voted to convict him, a smaller number voted to give the death penalty, but still it was enough to do it. And he was executed for basically trying to help people think. So pretty unjust, right? That's not the best way to do it. If a judge could have looked at it and sort of, well, this is the maximum penalty for this crime. The death penalty is not allowable, right? Or whatever, right? Wouldn't that have helped Socrates? Sure. So sentencing guidelines can be a help, and then it prevents people from, say, I mean, you have the minimum as well, right? But sentencing guidelines have gotten to a point where you get some real problems with them. One of those problems is that it doesn't allow for variation. For a judge to be able to say, hey, this case is different from the others. It should deserve less, or it should deserve more. If there's a minimum and a maximum, the judge doesn't have that freedom. Sometimes the people who set the laws set them unjustly, right? We have to think about that. That's a really important principle of justice. The judge is then bound by law to do what they're going to do. But those aren't the worst cases. The worst cases are not when the laws themselves are getting it wrong. Although, for example, people have often pointed to the crack cocaine versus powder cocaine difference, when there's no difference in the actual crime. It's just that the type of use of cocaine doesn't have any bearing on what the, right? It's just that one's more used by white people, one's more used by black people. That's unjust, right? But there are issues with the sentencing guidelines like that. But the more important thing, it's more subtle, it's harder to notice, is that three strikes laws and the use of things that are not relevant. So often sentencing calculation is done by a judge that takes into account a bunch of factors, and they're supposed to increase the number of years of a sentence, say, if certain things are true. One of the things in that list can be a crime that they were accused of that they got acquitted of. They were literally declared not guilty of that crime, and that can increase their sentence. How can you be more unjust than that, right? That's something they didn't do and the law declared them not to do, is somehow increasing their sentence. Some of the sentencing guidelines have stuff like that in them. That's really, really bad, right? And sometimes, here's the problem with the three strikes laws. So suppose you commit a crime, you get your sentence. You do your sentence, you're done. You're free, right? You've already done your time. You commit a second crime. You do your time, you're done. You are free. With some of these three strikes laws, the crime that you commit the third time could be a measly, tiny little thing. And then you're going to get 25 years for it. Is that just? Now, what people would say is, well, you're not getting 25 years for that crime. You're getting 25 years for the fact that it's a third crime, right? But even so, you wouldn't have any penalty with just the two because you're already done with it, right? You're getting that 25-year sentence for stealing that pack of gum. That seems thoroughly unjust in terms of proportionality, right? But that's what three strikes laws can do, that kind of thing. So we also, when we're thinking about sentencing, we need to take into account issues like treating children as adults. When is it appropriate to do so? Some states do so at particularly young ages. When we keep in mind that brain growth doesn't stop until age 25, that I think is a good argument for not having that practice. In fact, I'm not sure even trying an 18-year-old as an adult is all that just in the light of that. But there's no state that treats adulthood as 25. Is that a problem? I think so, actually. I think we need to recognize that the age of most college students, they're not fully grown yet. They are not. There are ways to help foster in them ways of making better decisions, and I try to do that as a parent of children that age and as a college level instructor. When I've got my own students I'm dealing with, I try to foster in them good decision making skills. I just did a video talking about that with the use of technology in the classroom, but they're not there yet. They need the time to get to that point, which is why rental companies charge higher rates until they hit 25, right? So certainly there's I think reasonable arguments for not treating a 13-year-old as an adult when they commit a serious crime. Does that mean that the laws for children are all right when they're treated differently? No, not necessarily. I mean, there's people worry, are we not treating children? Are we treating them too mercifully, right? Then they reoffend, right? How do we do that? We need to find that balance. We need to figure out how to do that. But nevertheless, a 13-year-old is not an adult. Treating them like they're an adult just because they committed a grievous offense seems thoroughly unjust, right? So and you can look at prison conditions and things like that as well. Prison conditions is part of sentencing. When we're sentencing someone to 25 years, solitary confinement, for example, is particularly cruel. And it may be that what they did to their victim is even worse. So you're not doing something worse to them than what they did to their victim. Okay, that's true. But that's the question. Is it loving to a human being to put them in an environment where they're not going to have any contact with other people? How does that fit with the principles of restorative justice? How do we help them become a better person? Even if they're never going to see outside of the prison again in their life, can we still help them become a better person if they're in solitary? I don't think so. So it's things like that are really important, and we need to be. Matt is very clear. We need to be really concerned about issues like prison rape. We just need to be, and that's immoral. It is unjust. We shouldn't want that. It's not a matter of whether we think they deserve it. That being done to them is wrong, and we need to care about that, right? So what are we sentencing someone to when we send them to prison? We need to keep our prison system is not what it should be. We need to rethink that a lot. So lastly, the death penalty. So I've taught the death penalty many times in my classes over the years. Really difficult questions when it comes to that. From a Christian perspective, though, there's a couple principles that are really important, and Matt gets this right. He gets this right. Um, um, there is a biblical command to institute a death penalty. So those who think that it is always in principle wrong to have a death penalty, if they are Christians, they are going against their own sacred text. That's just absolutely clear. So There are people who hold to what they call the consistent life ethic. I think the consistent life ethic is, um, if it includes never being okay to have a death penalty, is not biblical. It is wrong. If you hold to the biblical texts as a guide, as Christians do, it doesn't seem to me like you can hold such a view. So, um, nevertheless, many people who say they hold the consistent life ethic are not saying that it's always in principle wrong to have a death penalty. They just believe that in our current society, it's not necessary. It might have been in earlier times with nomadic peoples like ancient Israel during the time of the wilderness wanderings. But when you can have life in prison as an option, you don't need it. That's the Catholic view. And there's others who will say that it's, and this is Matt's view, um, it's um, a the fact that our system doesn't do it justly is enough reason to put it on hold. That's really his main argument here. The Supreme Court of the United States actually said that in the early 1970s, like 72 or something like that. They had an opinion that said our racial disparities in uh, criminal justice are so bad that we cannot do it justly, and until we can show that we can, we're going to put it on hold. And by 1976 or 78 or somewhere around there, they several states tried to bring cases to say, we're doing it now in a more just way. Can we do it again? And the Supreme Court at that time, it was a slightly different lineup of people, but mostly the same people, said of some of those cases, yes, you can, and of at least one or two, no, you can't. You're not there yet. So in their judgment at that time, a lot of those problems had been dealt with. So, what are those problems? Well, mostly racial bias, but it was much more explicit and open and clear that it was happening at that time than it is now. What we have now are just disparities in outcomes. There's no, when we see deliberate bias, there's a remedy for that within the system. But there's no remedy for much more unclear implicit biases and things like that. How do we know that they're there? Well, there's clear statistics, absolutely clear. Someone with darker skin is more likely to get a death sentence than someone with lighter skin. Someone whose victim is black is much less likely to get a death sentence than someone whose victim is white. And you see these disparities in other groups too. Women victims more likely to be a death penalty than male victims. Children as victims much more likely to be a death penalty than adult victims. And you might argue that that particular one makes sense, but certainly it shouldn't for race. So and this is so when you control for all the other factors that you might, people who are skeptical of this will say, well, what about this other factor? You control for that and you still get a similar result. So these biases are real. They're there. Some of it has to do with their ability to identify with the victim. Some of it has to do with our ability to identify with the defendant. And if we're going to be unbiased, we need to be able to do both. We need to be able to think through circumstances that we would allow to count as extenuating circumstances and give a life in prison sentence rather than the death penalty with a white defendant. We should be able to do that with a black defendant. And since we can't do that, it's demonstrated that we can't do that, then our system is unjust. And Matt's argument is we shouldn't have a death penalty if you were even doing that with one case, never mind with the large number that we're doing it with. So, I have not always found that argument as convincing. At some times in my life, I've been aware of that argument. The details that he presents show the problem to be a little bit worse than even I understood it to be, and I did understand it to be bad. So I'm a little bit more willing to give that side some support than I was before I read the book. I'm not sure I'm completely sold on it as in terms of a ban. Maybe there's some middle ground approach that you could have, but he really has some good points in that chapter. So overall, I consider it a great book. I really have hardly anything that I would say against it. I really think it's an absolutely wonderful treatment of these topics. The picture that he presents of biblical justice is thoroughly and soundly biblical. Anyone who comes from any remotely traditional view of Christianity that sees Scripture as its guide would I think find this very convincing as to a picture of what justice should look like. There's a lot of great detailed information all throughout the book of what our criminal justice system actually looks like, why that's bad, why we should care about it, why we should try to do what's within our power to make it better, and if people are actually in the justice system themselves, ways that they should function. That would be much better. So there we go. Matt Martens. Uh, get this so that actually shows reforming criminal justice, a uh, a Christian proposal, and Crossway books. Absolutely wonderful book. I highly recommend it.